Good afternoon. Thank you for being here. My name is Matt Kugazaki. I'm an attorney and pro bono coordinator at Inland County's Legal Services. I think I've talked to a bunch, and I'm sure a lot of you have received emails from me. Thank you for being here. ICLS is a 501c3 nonprofit organization that provides free legal services to residents with limited means in Riverside and San Bernardino counties. I help run our small business legal program, which aims to help entrepreneurs, small business owners like yourself have access to legal information, resources, and guidance, which other larger businesses and more established businesses have. Today, we're very excited to provide this informational webinar as part of our Small Business Essentials Summer Webinar Series. It's on probably two of the most critical topics for small business owners, which is entity selection and contracts basics overview. These are critical topics. We're so happy you're here. Please note that the topics covered today are for informational purposes only. It is not legal advice, and you're not creating an attorney-client relationship with anyone who presents today. However, as mentioned during the webinar, ICLS has opportunities for you to meet with an attorney on a one-on-one basis, and this is for eligible small businesses. So some of you have already signed up for that opportunity. We've gotten you through the eligibility process. If you haven't started that process, please feel free to email me or reach out to ICLS. You'll have my contact information. After this webinar, I will be sending an email to everyone, so please feel free to do that. And now on to the presentation. We are partnering today with Simpson Thacher, one of the absolute best law firms in the country. We're partnering with their corporate practice who advises businesses of very large sizes, of all sizes, on corporate issues. So we are in very good hands today. We cannot provide our services without volunteer attorneys. This is especially true for our small business clinic. And we are so grateful to have the expertise from Simpson Thacher today. And with that, I'll let them introduce themselves and hand it off to them. Thank you.
Hi, Matt. Thanks for the kind introduction. My name is Jesse, and I'm here today with my coworkers, Jacob, Marielle, and Christian, who I believe is joining us remotely. We're really excited to be presenting to you guys and gals. And with that, I think we can get started. We'll go to the next slide, which I think Matt previewed, which is just that, the contents of this presentation. I'm going to read it again just because this is our slide, and it basically says that the contents of this presentation are for informational purposes only. None of Inland County's Legal Services, Inc., Simpson Thacher and Bartlett, LLP, or the lawyers making this presentation are rendering legal aid or other professional advice or opinions on specific facts or matters. The viewing and or distribution of this presentation to any person does not constitute the establishment of an attorney-client privilege or other relationship. Simpson Thacher Bartlett and the lawyers making this presentation assume no liability in connection with its use.
So the next slide here is just going to be an overview, signposting, where we're going to go today. We're really going to hit two topics, entity selection and contract review, as Matt said. But, one of the topics may be more applicable to you than the other. I know some folks already have their entities selected, so to speak, and so the contract review will be more important, or vice versa. But just hang with us through the whole presentation here. We will have a Q&A at the end of every section, but honestly, if you're courageous enough, you're more than happy, if the technology permits, to interrupt us. Just note that we will be speaking only in general terms and not specific to your business or the specific facts of your business. And then we'll go on to next steps, just things you can get started on to do. What are things you can consider as you go forward, either drafting contracts or selecting an entity.
This is just a general slide that outlines what we typically do at Simpson Thacher. We host small business clinics through our New York and our Palo Alto and LA offices. And we primarily work with other nonprofit organizations, in this case with Inland County's Legal Services. And they typically will screen groups or businesses to see if they qualify for our services and our advice. And if they do, then we will meet with them typically in bi-weekly or monthly clinics. And the clinics are conducted on a limited scope waiver, so there's no ongoing attorney-client relationship after the meeting. However, in some instances, our firm pro bono program does take on certain clients for full scope representation, which would include assisting with entity formation, drafting contracts, and advising on more complex, individualized questions and structures. I think more information can be provided on that in a couple of weeks if you do show up during the clinic that we have on July 20th.
We've already kind of reiterated everything here, just, mentioning, if you want to reach out to Inland County's Legal Services after the presentation to schedule a time for an individual limited scope discussion, feel free to get in contact.
With that said, we'll move on to the part one of the presentation, which is entity selection. And generally speaking, when we are talking about entity selection, we want to look at a few key questions. And these, generally speaking, are what kind of features and benefits are you looking for in an entity? And that really, primarily when we talk about entity formation, we're looking at personal liability protection. So basically, for instance, if your business gets sued, we want to protect your personal property, like your house, your car, your savings, first against any lawsuits that might be targeted at your business. A couple of other things we'll be looking at today are taxes and how each entity has potential tax benefits or, I guess, tax implications. And also, the next thing we'll look at is the ability to attract potential investors or to raise money from other groups of people or organizations. And we'll also look at the organization and the structure type. So like how an entity may have to be, I guess, taken care of, or like just how certain entities may be more flexible than others. And again, the factors that we consider are basically the same, but a couple of things that might affect business owners and entrepreneurs are the ownership or governance requirements, and one smaller but also significant piece would be cost of formation and administrative requirements.
So the first business structure that we're going to discuss is a sole proprietorship. So this is when an individual is operating a business and does not have a separate entity that they've created for the business. The biggest thing to be aware of is, as Jesse was mentioning, there's no limitation on personal liability for a sole proprietorship for the owners. So if the business is a restaurant and someone gets sick and decides to sue the restaurant, then the personal assets of the owner, like their car or their house, could be used to pay for anything related to that lawsuit. So this can be mitigated a bit with insurance, but overall, there's nothing in the structure of the business that's protecting the personal assets of the owner. In terms of taxes, the individual is taxed on the profits of the sole proprietorship. That's at both the federal and at the state level. In terms of ownership, it's just that the individual owner owns and operates the business. And in terms of governance and administrative requirements, it's very simple. There's nothing that you need to formally file, no formal fee that you need to pay. Although if you are doing business under a certain name, then you should file for that name. So overall, the kind of advantages and disadvantages when compared to some of the other entities that we'll discuss in more detail in a moment, there's just one layer of taxation, just that the individual is taxed on the earnings. It's relatively inexpensive to form and to maintain. You could easily convert it into a formal entity if you chose to. The biggest disadvantage is that there is no limitation on personal liability of the owner. And it's possible it may be a little less attractive to customers since it's not a formal entity. And then lastly, upon retirement of the owner, the sole proprietorship or the business dissolves since it's not separate.
Yeah, and if you're a sole proprietor, it's not that you have to pick a legal entity. A lot of our clients choose to stay as sole proprietors because their risks of like getting sued, of being personally liable, are very small. For instance, someone selling, I think baby socks was one of them, who stayed a sole proprietor. They didn't find that they would be that that there was a huge risk of litigation. And so they decided the pros outweighed the cons. They stayed a sole proprietor. Similarly, though, if you're expanding your business, like we had one client who was expanding their daycare business, they were trying to get a bigger license to have a larger daycare business. And in that movement of their business, they saw, a higher risk of litigation. And so they decided they should form a legal entity like the next one, which will be, oh my goodness.
So the next is a limited liability company. This is probably the most common entity form that's used for startups or small businesses. As the name suggests, there is a limitation on the personal liability of the owners, or as they're called in an LLC, the members of the company. In terms of taxes, it's different at the federal and at the state level. At the federal level, there isn't an LLC specific tax regime. Instead, you would choose to be treated like one of the other entities that we'll discuss. And depending on what you choose, there could be only one layer of tax, or there could be two levels, as we'll discuss shortly. At the state income level, it's different. There is an $800 LLC fee that you would need to pay annually. And then in addition to that, the members or owners also pay income tax on the earnings that they receive from the company. So that's one of the bigger expenses with an LLC. In terms of ownership and governance and the administrative requirements, it's comparatively flexible. You do have to have an operating agreement, which is the overall agreement that dictates how the company is run, but it's really flexible. You can write pretty much whatever you want because it's not governed by a statute that has very strict requirements. It's simply governed by contract law. So you could have different members that have different economic or voting rights. You could have the company run by one of the owners, which is called a member managed LLC, or run by someone who's not an owner, which is a manager managed LLC. And we have examples that we've provided in the manual of an agreement, both a manager managed and a member managed that you can use. But again, you don't have to strictly abide by those forms. And in terms of administrative requirements, it's flexible. Again, it's what you write in the operating agreement, although you do need to file a statement of information twice a year. That costs $20. And the other fee to be aware of is a $70 one-time filing fee when you initially form the LLC.
And a correction there, biannual meaning once every 2 years, not twice a year. No, it's one of those really ambiguous words. Yeah.
So overall, the advantages, at least at the federal level, you can elect to be treated as just with one single level of taxation. Instead of having two layers of taxation like a corporation. It's generally flexible in terms of the operating agreement. Some disadvantages, some investors may prefer to see the company change into a C Corp. It might be easier to transfer membership interests in a corporation as compared to an LLC. And the operating agreement, while it's flexible, might take a little more time to construct as just because of that flexibility.
And go for it.
And one thing to note on the governance and administrative requirements, LLCs are really flexible. Technically, you don't actually have to create an operating agreement. And at that point, your LLC will just run under the LLC Act of California. However, as a firm, we don't necessarily recommend that just because there are certain things that you as a business owner may want to have your company focus on, or just you want this option to be available. For one example we always provide is LLCs don't require that you do that you create like resolutions or meeting minutes or have any record of that written down, but we always recommend doing that from a doing business perspective.
I guess another point to note is just LLCs are, I think the majority of folks that come to us and create an entity, they create an LLC. That's why we have it first. It's just the baseline entity. If anyone's like, oh, you should create a company, it's probably they're thinking an LLC. And so it's a good one to start out with, so you can think about how the other entities we talk about compare to this one.
Okay, so now we're going to talk about C corporations, which is what you think of when you think of big corporations like Google. They're all Facebook, they're all C corporations. So a big thing with C corporations is they also have very strong personal liability protection. But as opposed, in comparison to some of the other entities we've talked about, they have a much heavier tax burden. So when you have a C corporation, you're taxed twice at the federal and state level. You have to take corporate tax and your personal individual income tax when you take money out of the corporation. So this leads to much more taxes than some of the other things that we've talked about. Another contrast is governance, which is kind of unique to the C Corp and the S Corp, which is what we're going to talk about next. So there's shareholders, board of directors, and officers, which is sort of three buckets. The shareholders are like the owners of the corporation. The board of directors sort of make the big, large-scale decisions. They're steering the corporation, and then the officers, which are usually appointed by the board of directors, sort of are making the day-to-day decisions. So that's different than some of the other entities we've been talking about. As well, the administrative requirements are a little bit more onerous. You have to have annual meetings. You have to take good record keeping, which is, one thing Jesse just talked about, the LLCs you don't always have to do. And so those are much more of a heavy lift than some of the other things. So just three things to really remember about the corporation is that there's strong personal liability protection. They're attractive to investors, but they are subject to double taxation.
Yeah, I mean, at one point to one of those Christian's last points, they are more attractive to investors. Investors may request that you actually convert into a C corporation just because it's easier to issue stock, it's easier to grant equity grants to employees, and some investors are just used to it, right? So it's a normal construct, a business construct, where an LLC is, governed by an operating agreement, and you can do anything with that operating agreement, but it might take a lot of time, a lot of attorneys, if you have those available, and or accountants to really look at it and think through all the provisions. Where a C corporation is governed by shareholder agreement and bylaws, and a charter, and so, to that extent, it is a little bit more formal, and investors have a little more familiarity with it sometimes.
Right, and I think I'll just expand a little bit on what Jacob was mentioning in terms of employee or other types of investors buying into the company. With an LLC, the flexibility is there, but in order to have like a second class of equity awards, or like saying like you want to incentivize your employee to reward them for helping out, creating that second class of membership interest that doesn't have an ownership right within the LLC can be pretty complicated, and that's because within an LLC, within the LLC entity, every member that owns an interest of that entity, let me take it a step back. Everyone who has an interest in that LLC by default is a member and has voting rights. So to bifurcate the voting rights away from that and just provide like a dividend sort of, so to speak, is a bit more complicated. Within a corporation, it's much easier to create a new class of stock that may have just a monetary award or rewards available.
So the next thing is kind of a contrast to the C Corp as an S Corp. So the S Corp also provides strong personal liability protection. And the tax burden is a little lighter than the C corporation. So at a federal level, there's only single taxation. So there's no corporate income tax at a federal level with S Corps. But on a state level, there's still the same double tax, where you're taxed at the corporate rate and then as individual income when you take money out. One thing to contrast with the C Corp is that S Corps are limited to having only 100 shareholders who must be US residents, whereas C corporations can have unlimited shareholders and it doesn't matter where they're residents. And in contrast to sort of what Jesse was just saying, S Corps can only have one class of stock. The governance and administrative requirements are the same as a C corporation. So the main thing to note and the main contrast is that there's a slightly lower tax burden, but you're limited on the number of shareholders and the type of stock.
So in addition to what the entities that we reviewed on this presentation, there's a few other entities that are perhaps unique to California compared to some of the other states. And there are B Corps, there are co-ops and other less common entities, and those are all described and summarized in our entity matrix, and those can be found within either the LLC formation manual or the corporation formation manual. Before we go to an overview, I wanted to see if there's any questions from those that are on at the meeting.
Okay, we can continue. Yeah, and we provided the manuals for the two corporations we went over. We also provided a manual for the LLC. Those other entities, they're a little bit more specific, probably not within the breadth of our presentation here, as Jesse was mentioning. But they're not too much different. Just to highlight something about a B Corp, because I know we actually, I think, have one listening in here. It's very similar to a corporation. It's taxed similar, but you would add one proviso in your charter to tell the state of California, like, hey, I'm a B Corp, and then also you would have to have certain public benefits you are working towards, and you would actually need a third-party standard to work towards those goals, and you'd actually even have to issue a statement of information about those goals, annually. And so there are more onerous requirements for some of them, especially B Corp. And just based on some of the descriptions of the businesses you guys were, you might be considering that, and it's worthwhile to consider. Just know it might be a little bit more onerous than any of the entities we talked about today. And then, so in summary,
yeah, so we'll just highlight some of the main topics when you consider forming an entity for your business. The main thing is limited liability. If you decide to form an entity, whether it be an LLC or a corporation, a C Corp or an S Corp, or a B Corp, we want to emphasize that you should run your business as a business and observe corporate formalities. And the reason why is there's a legal concept called piercing the corporate veil. And essentially what the law can look at is that if you are running your business as basically just a shield against your own personal liability, but you're just using this business as your like a shadow of yourself, and you are acting in a way that isn't really just for the benefit of the corporation or the LLC, the law can actually go pierce that liability protection if there's any kind of lawsuit that's formed and still go after your personal assets.
For tax treatment, we mentioned it, but at the federal level, the C Corps are subject to double taxation, as well as and then C Corps and S Corps subject to double taxation at the state level. That's why, a lot of people pick LLCs or S Corps just because they have, less taxation burden. And, you may want to talk to an accountant about which entity works best for you. I know I mentioned the daycare, a few slides ago. That daycare actually chose to be an S Corp because their accountant, referred to them as it being a lower tax liability. And also, they didn't need more than 100 investors. They weren't looking for investors. They weren't looking for a wide breadth of shareholders. And so that was their considerations. You always speak to an accountant to consider your own tax liability, noting LLCs have an annual $800 franchise tax. There's also an additional fee. We didn't really get into it. Once you're making enough money, I think it's $250,000, you may be subject to an incremental income tax as well for an LLC, but that's when things are going really well for you right there. So we wanted to just get you towards forming a business at this point.
And one thing to note too on the LLC tax treatment at the federal level, we're saying in our slides that LLCs are not subject to double tax. And that's because typically most people, when they form an LLC, choose to have their entity as a pass-through. They choose a pass-through taxation set up for their federal level taxation. So at that point, we're saying, hey, it's not going to be double tax. You can always choose to have your LLC taxed as a corporation if you choose. There are some reasons why people do that, but I think it's beyond the scope of this presentation. And with the upfront costs, we want to remind the group here that forming a legal entity typically has initial costs ranging from $70 to $100 just to form the entity, and an annual or a biannual recurring fee of $20 or $25. And I just got an email today. I think California Secretary of State has waived the filing fee for all new entities. So whether it's foreign or domestic, so whether it's a California-based entity or a out-of-state entity doing business within California, they're basically making it free until June 30th, 2023. I think they've been doing this since COVID started, so they're just rolling forward another year.
Great, so it's free. No excuse. And then just as a good point to note that there's upfront costs for creating an entity, and you can also change your entities, right? You can convert from an LLC to a C Corp or vice versa. And depending on what entity you're converting into and converting from, it can be relatively cheap as well. I think some articles in conversion, are a $20 fee, and then you can just change to a whole different entity. So it's relatively easy to change entities. If you find like, oh, I really don't like the C Corp, the formalities are too much, you can change it to an LLC. I think we've actually had someone do that, and vice versa. So that's just something to note. This isn't an end all be all. You have to decide for the rest of your life, of your business anyway. You can change it. Going on, I think we already mentioned, but ownership LLCs and C Corps are more flexible. S Corps have restrictions, right? So you have to be a U.S. citizen or a permanent resident, depending on the folks around you in your community and your family who you may want to be investors as well into the business. This is something to consider, because while an S Corp, has positives like lower tax treatment, it does have this restriction that you don't know. Maybe in the future you will want certain folks to invest, and now they just can't, and that's a bummer. So that's just something to keep in mind when thinking about it.
Yeah, I think one thing that reminds me of is, I know there's a lot of larger corporations out there that do like to fund small businesses. I think like during the pandemic, Facebook had grants available, and I'm not sure if these grants if it was just a one-time thing or if there were kind of interest involved there. But that's an example of where an S Corp might be a little bit more limited. So just again, something to keep in mind. Next point is governance and administrative requirements. So there are certain corporate requirements that Christian discussed for corporations, and that may be augmented. They're prescribed by statute and may be augmented by the corporation's bylaws. So like the annual shareholders meeting, having certain votes for certain types. Like if you wanted to pass if you want to vote in new members or new officers rather, or new board of directors, you'd have to have a meeting to have that vote occur. By contrast, LLCs can be basically, they're easier, they're less burdensome because by statute or by rule, they don't have these requirements, or they can be implemented via an operating agreement. But regardless of whether or not you choose a corporation structure or an LLC, we always say, hey, you should have these types of meetings. Even as an LLC, if it's just you as the only member, and you want to create a contract or like sign a contract with a business partner or a service to bring something in, we always say, hey, you should memorialize that. It can be as simple as an email saying, hey, because this member, I as a member, or the member thinks that this business agreement may be beneficial for our LLC, then as a member, I consent to that. It can be an email to yourself. It can just be a simple one-page document. It doesn't have to have the multi-page formalities that you might see with larger corporations. Same thing with the financial statements. I know that there's a requirement on the corporation side, but it might be beneficial too for an LLC to have these annual financial statements and just kind of, you present it to the LLC. And if you're just the only member or if it's a small group of members, you can just reply all via email just saying, hey, I've seen these financial statements and they look okay to me.
Next bullet here is Delaware versus California. Now you can incorporate literally in any state in the union, but Delaware is where a lot of companies incorporate, especially like very well sophisticated companies, just because Delaware law is really built up on the corporate side. So that's just why a lot of people go to Delaware. That's not to say California doesn't have very well established law as well. And generally a pretty efficient Secretary of State system. Delaware is generally more expensive, and assuming you are operating in California, which I would think anyone at this presentation will be for their business, you would have to pay taxes in both Delaware and California if you were to incorporate in Delaware. And there would also be a number of forms you have to file with California as well. So it's administratively burdensome, and so not something we generally recommend. But you can always do it, Delaware or otherwise, Montana, if you'd like.
One thing to note about the Delaware versus California distinction is, the internet has a ton of resources available. A lot of examples for either an LLC operating agreement or a charter for your corporation or bylaws. If you do decide to go online to look at examples, aside from the examples that we provide in the formation manuals, we highly just want to give you a warning that you want to make sure that you're looking at the right piece of technology or the right agreement for the state that you want to create your entity. And so there are different requirements by statute for Delaware compared to California, compared to Montana or Nevada. And so we just want to make sure that flag that if you are looking online, you are aware of those differences. The conclusion bullet is basically what we talked about here. So I won't go through that, but we'll go to the next slide instead.
Great. So, we just told you a lot of information. It'll probably have to take a few, moments / days / weeks, what have you, to sink in. But, once you decide what entity you want to form, looking at the manuals, maybe looking at some online resources as well, unless you want to just, base it off this presentation, what you'll do next is form your entity. And so when you're ready to form, there are free legal services that can assist you in that formation process to help you draft those documents that are required. Now, again, we already provided 2 manuals that will pretty much walk you through creating either a corporation, S or C Corp, or an LLC, and they do have form documents included. But if you do need extra assistance, there definitely are intake processes to go to pro bono services, any of which are available. I assume Inland County's Legal Services can help provide some assistance there. But like we said, many businesses also form without counsel. There are 2 extra websites here that you can visit that will give you good guidance, as well as our handouts.
And one other resource that we also have looked at and think provides pretty decent forms is it's a website called Up Counsel. They have California specific forms. They have California specific general advice as well. So I think we might have forgotten to put that up there, but that's something that you can take a look at. And of course, if you ever have any questions and things, I think the basic premise is to make sure that you understand what's going on with your operating agreement or with your LLC or with your entity before just moving forward. The resources that we give you in the formation manual is basically like giving you the keys to a car, right? But learning how to drive it or understanding it may take a little bit longer. So that's why we recommend always talking to seeking clinics if available to you.
And then, you've formed your entity. Wow, that was fast. So now, there's just some things to keep in mind as you go about your business. First and foremost is always signing documents for your business with the name of the business entity rather than your name. Now, what this will look like is really you'll have the name of your company. Let's go Bob's Burgers, I don't know. And then you will sign it your name. You'll even have your name, Jacob Gint, and then you'll put a comma and you'll put your title, your officer title, whether you're the manager of your LLC, whether you're the CEO of your corporation, you'll include that there. So that's designating, hey, the company is signing, right? My entity, Bob's Burgers, is signing this document. And who is signing on its behalf? Me as what? The CEO, me as the manager, et cetera. And so that's how that would go on any of your business documents going forward.
The next thing we always recommend is to hire an accountant. I know this might seem super basic, but we when we talk to a wide range of intake folks, sometimes they don't have an accountant, and at that point we recommend at least accounting software. When you first make the step from a sole proprietor over to an entity, it may not seem like a significant benefit, but as you become as your company or your entity starts becomes more complicated or grows in business, an accountant, they're professional service, and they are there to help you with any tax nuances or otherwise.
The next bullet here is do not mingle personal and business funds or assets. This is probably one of the most important. Jesse was mentioning before about how, if you're audited, if the state investigates you and they find that there isn't a distinction between you and your business, they might say that business is a fraud. This doesn't provide you personal liability protection. And this is probably the biggest factor in that consideration is if you aren't, separating your funds, your personal funds from the business funds, that is a red flag. So be sure to do that. Be sure to have a different bank account and expense, your business expenses to that account.
We always recommend that folks maintain an organized set of records, just copies, backups, just in case you either lose your phone or, God forbid, a fire comes through a business and destroys your printed records and your receipts are gone. There's a ton of, online cloud services that provide you secure backup technology. And there's also a bunch of free sources such as Dropbox, Google Docs, or Gmail that you might consider if that falls within your budget.
Another one here is keep up with statutory requirements and formalities. So this is really just, getting your paperwork in line, making sure that you're doing all the things we've already mentioned, like holding required meetings every year if you're a corporation. And just noting that, you don't need a big conference room like the one we're in. You really don't even need a conference room from a hotel. You really don't need a conference room. You just need to hold a meeting, and that meeting just needs to be codified on paper. And you may be the only shareholder, and so that's going to be a very easy meeting for you to do. But you just have to do it. It doesn't have any strings attached. There's no frills about this requirement. You just have to hold a meeting. It can be in your basement if required. Something like that is fine.
And just to reiterate on that point, with some of the public companies that we've worked with, we have seen records or we review their meetings, and it has board of directors just replying with I agree or I consent through an email chain. And once every board member for a corporation, every member for an LLC has consented, then that's a unanimous consent for whatever action that they were voting on. So it can totally be very easy to do. Additional resources are available at this website. Encourage you to take a look at it when you have the chance. Before we move on, we wanted to see if there are any questions again before you go to contract basics. Okay.
All right, yeah, let's go. So now we're on to our second topic here. We're going to go over contract basics. So some of the first few things that you really should consider when drafting your contract, when considering your business and how contracts interact in your business, is how sophisticated you and your counterparty are, right? If you are contracting with Google, unfortunately, they probably have a higher level of sophistication than you do. They have processes with controlling all their contracts and negotiating contracts and internal policies and what have you. So just consider that. Consider, you may have customers that aren't probably going to read your form contracts or are not very contract literate. So they won't understand some of the nuances of contracts you have. So you may want to explain those nuances to your counterparty if you think that's pertinent for your business. Your bargaining power. This is kind of to the level of sophistication too, but who has the leverage in your business interaction? And you should really keep that in mind when negotiating your contract. If you do negotiate your contract, right? You may not push on provisions if you really want to be in business with your counterparty, you might, be willing to accept a lot. And so, these are basic negotiating points as well. Surely something you probably considered within the context of your business, but always good to keep in mind when you're actually thinking about the actual contract as well when you're drafting that. Oral contracts can be legally enforceable, obviously with certain qualifications and carve-outs to that based on a long string of legal precedents, but we always just advise to avoid them. If you can say it out loud, you can write it down. And if you can write it down, then you can refer back to it and help, remedy any disputes. Really just have it codified somewhere is super helpful.
So moving forward, like when we talk about drafting contracts, again, this goes back to the internet. Like if you want to draft your own simple contract with just a car sale, for example, just party buyer, seller, cost, and sold as is, signed, and that's a contract. That's perfectly good. I'd probably throw in the VIN in there as well, and data sale. But other contracts might be more complicated, and so then you might want to go to the internet and find a form or a free draft. If you're going on the internet, again, make sure it applies, it makes sense, and that it does make sense to your situation. If you're going to use a counterparty's contract, make sure again it makes sense. The bottom line here is that you want to understand the contract that you're signing, and if there are any questions, to ask yourself, like, is this something that's important enough that I should figure out or ask or bring to legal counsel for advice. Intentions of the parties. So this goes back to the oral contract flag warning that Jacob talked about earlier. Even though the intent of a party may be very friendly, and it may sound like they're very interested in doing business with you, you want to make sure that what the contract says, like, or what you and your counterparty think the contract is about, is actually reflected within the written contract. Next slide.
So just more factors to consider when thinking about contracts, right? What kind of contract type is it? Is it your operating agreement, right? That's going to be a you thing. That's going to be a your business thing. Whereas an employment independent contractor agreement might have certain other provisions you want, expectations from your employee, maybe making sure that any IP they create is yours. Those kind of provisions, which we may discuss later, are pertinent in that agreement as opposed to some other kind of agreement. So just first reflecting before you even do anything with your contract, what kind of contract is this? What do I want from it?
Governing law. So this is a thing where you can definitely contract or like just agree to through a contract. You want to make sure that the governing law is something that you guys have agreed to. There are some service agreements or purchase agreements that say, hey, or even a lease, for example, like a home lease, that say, hey, if there's any dispute, you're going to go to their state. So Illinois or New York is very common. I don't know why I said Illinois. But for example, if you are working with a local business partner and they want to, they present a contract that says, hey, governing law for any disputes within this agreement will be New York. You want to flag that. That could be a mistake. That could just be an indication that they found a form online, and at that point, you might want to take a closer read of the contract.
Amendment. How can the parties change the agreement, right? We all make mistakes. We all have misconceptions. We all just didn't think about something when the agreement was being drafted. Even huge companies do this. And so it's totally plausible that you may want to change the agreement as well. And so how can you do so with your counterparty? Maybe if you have a lot of counterparties to the agreement, maybe it takes 2/3 majority to do it. But usually most agreements we see is it has to be in writing between all the parties involved. But that's something to consider.
Yep. And then finally, the final factor, I think the most important factor is a reality check. Does the contract actually make business sense to you as well as legal sense? And the example here, a bakery that can contract for no cake cancellations under any circumstances. Will someone want to shop there if they have, a last minute cancellation due to a medical emergency? Another example might be, if you're providing services as an independent contractor or a designer, web designer, if you offer your services 24/7, does that make sense? If someone's going to call you at 4 a.m. So again, you just want to make sure that the contract makes business sense for you as well as legal sense, in that the contract reflects in writing what you are offering as a service. Okay, so we're going to go on to some key provisions that we'll talk about, and I'll hand the mic off to Christian.
Yeah. Okay. Yeah. So we're going to go through some key provisions and sort of explain them and give an overview. So, number one, who are the parties? Who's signing the contract on your end and on the other end? And sort of going back to what we've talked about, it should be the business entity signing, not you in your individual capacity. So you sign in your role as the officer or owner of the business. Another thing to check is if the names are all correct, because it is a legal document. So another thing is, it sounds kind of self-explanatory, but what's the point of the contract? You got to make sure that the description of the goods and services are clear and unambiguous, and you need to make sure that and that the nature of any obligations are clearly laid out in the contract, sort of the who, what, where, and when.
For example, for that one, right? So what's the point of a contract? One example we had was we were providing a contract for someone to provide lawn services, right? And you can either go two ways. You can either say, they'll provide, gardening, lawn services in a manner consistent with industry standards, right? And that's an objective standard, right? Where people can kind of look at what other gardeners, what other lawn services provide. Or you can list all the services you actually plan on providing, but that can also get while being clear, incredibly complicated, right? So you have to do these 5 different gardening services on this property, other gardening services on another property. You might do some of them bi-weekly, some of them every week, and they may change per season, right? Some things are different in the fall than the summer. And so things like that can be incredibly complicated. So it's important to, balance whether the services you're providing are clear. And so if there's a dispute between you and, in this case, like a landowner, you can look at a contract and say, no, this is exactly what I'm going to do. Here are even things I won't do unless you pay me more, versus, you want your contract to be business friendly and just say, we're going to do gardening services to an acceptable standard. So it's important to think about exactly how your services will be described in a contract and how clear you want them to be. But once you decide, I want some specificity, to be consistent with that specificity. Sorry, Christian.
No, yeah, thank you, Jacob. So the next thing is price, obviously very important. You want to make sure that the price, if the price is fixed or variable, if there's commission or salary, et cetera. And, there's a lot of different ways that this could be laid out in the contract. So you want to make sure that you know what it is and that it's favorable to you or how you want it. Another thing is conditions. So are there any conditions beyond execution that must be satisfied? So one example of this is we had a client that had in their contract that they would be available 24/7 for their customers. And if you have that in your contract, it literally means you have to be available 24/7. If they call you at 4 a.m. and you don't answer, your contract could be, ripped up, determined invalid, or you broke it. So you got to be very careful if there's conditions that you're signing up for, if there's conditions you want the other party to be signed up for. And lastly, on this slide, term. So this is obviously how long do you want the contract to be? You've got to make sure that the contract has an endpoint if you want it to. If you don't mention it, it might, in theory, go on forever, which might not be great for you. And another thing is, does it renew automatically, or does it, which side has the opportunity to renew it, et cetera?
An example to highlight some of those two last points, I think we were working on a contract for a talent agency. And so one of the conditions for the talent agency to be paid, right, because they work on commission, they're kind of a middleman, is for the talent to be paid. And so that's really important. If the talent wasn't paid, they weren't going to get paid. So thinking about that as a condition in your agreement, they included provisos that required the talent to use reasonable efforts to get paid, right? So it was it was an obligation of the talent to go speak to the client, to email the client and ask for payment so that the talent agency could be paid, right? So that's just them thinking there is a condition for us to receive payment. What is that? Can we mitigate that condition in any way that's positive for us? And likewise for the term. So they didn't want automatic, it's hypothetically plausible that a talent agency wouldn't want automatic renewals with their talent, right? They might want to renegotiate the contract with their talent. They don't want it to be plausible to just everyone automatically renewal. And so it provides a natural business point for them to think about their contract with their talent over and over again. It's a very personal business, so they may want to have that flexibility when they're thinking about how long their contract's actually going to go.
So another provision to think about in addition to the term is termination. How will the parties agree to end the agreement? Some things to consider are if you have to give notice before termination, how much notice you want to give, how much discretion is available. So are there only certain circumstances under which the agreement can end, or is there broad discretion to terminate just for convenience because you decide that you want to? And then also think about if there are any provisions that you want to still be in effect, even if the overall agreement is terminated. For example, indemnification, which we'll discuss on the next slide. Also, you could consider events of default or remedies. So you could try to anticipate, if there is a breach of the agreement, what specific remedies you want to apply in those situations, and you could address that at the outset when you're writing the contract. And regardless, if there is a dispute under the contract, you do want to consider how that's going to be resolved. So whether you're going to go through the courts or it's going to go through arbitration, where you would file any dispute, and what state law you want to apply. As we mentioned earlier, there might be some states that are more favorable than others.
And the termination provision, that's where, I find at least quite a bit of leverage of the parties is put. So you can have different termination provisions where you can terminate for cause, right? If someone is in breach of the agreement, they're not doing what they're supposed to under the agreement, you can terminate. But there's also something called termination for convenience, right? So you only have to provide notice. And once you provide notice, you can terminate the agreement. And often the party with the more business leverage will have a termination for convenience provision while the other party will not. So they can enter into the agreement, and then at any point, they just give 15 days notice and they're out of the agreement, right? And so that provides a lot of leverage for that party, right? If they have any bad terms in the contract, if they don't really like how it's going, they can leverage that. They can say, hey, if you don't fix this agreement, if you don't fix these business terms, we're just going to cancel the contract. We have that power. Now, you don't have that power. You don't have a termination for convenience provision. And so there's a different, in that term, there's a lot of leverage being exerted. And so it's just good to keep mindful of what that actually says in your contract. Maybe in your form contract, you want it to be, you friendly. So providing yourself a termination for convenience provision is probably, something to think about.
Yeah, and oftentimes too, if you have two businesses that may want to go into partnership together, they might both say, hey, actually, it might make sense for us to have this agreement, but either party can terminate for convenience. what comes to mind is like I have a friend who has a restaurant here, and they're looking for someone that can provide coffee for them in the mornings, on the weekends for brunch. But they may not know this the barista, so they might have an agreement that allows, if for whatever reason it just doesn't work out, both parties can terminate. With the notice, advance notice, typically what we see is 2 weeks, pretty common if it's maybe a half year or year-long contract. But if it's a shorter contract or an even longer, if it's a longer contract, then we would typically see a longer notice period, just because there might be a bit more reliance on that contract. For example, if it's a 2 or 3 or 4 year contract, you might want to give, or you might want to be able to have a longer notice period to say, okay, my agreement with this company or this business is ending. This 2 year agreement that I was relying on, but now I've got a month and a half or 2 months to look for another partner.
Yeah, and to that point, it's pretty industry specific, right? Like some software services, or your monthly cable bill, like you can maybe get out of that pretty quick. But if both parties are putting a lot to the contract, right? It's capital intensive. You both are dedicating lots of resources. You may want to have that locked and keyed and throughout the key kind of thing, where like it's going to be 3 years, no one can terminate except for breach. So that's something to just think about. It's very industry specific. It's that relationship specific.
To add a little bit on the events and defaults and remedies section, the example was given, like if someone runs into a default, for example, like 24/7 services does not respond at 4 a.m., that's technically an event, a default that could cause the contract to be voided by the party, or you could potentially sue under contract theory. But dispute resolution is very it's messy. It takes a long time. So oftentimes what we recommend is, what is a source of remedy, right? Okay, well, you can if it's 24/7, it's 4 a.m., you have until 5, potentially 3 times. Like you got you can build that into your contract so that it doesn't automatically go into default. There's a chance to cure the default.
Yeah, I guess one more thing, just because we have to keep upping each other, keep talking. For the dispute resolution, we didn't speak to mediation there. I've seen it a few times actually, where people put mediation, and as opposed to small claims court, which is, I think, pretty intuitive. And arbitration is kind of a mini court setting in a way. You have a judge, you have an arbiter that will decide, how it goes and who's right or who's wrong. So you have a third party, person that is deciding. Mediation is hiring a mediator, which is really just what it sounds like, someone that will mediate for you, will not decide the outcome of anything, and you can work through your business issues with the counterparty. So that is also a possible dispute resolution pathway. Just noting, though, that there are some provisions related to that, right? Who pays for the mediator? Will you be splitting the costs? Who's finding the mediator? And what if mediation doesn't work? You still kind of have to do one of these other things. So that's something I just want to flag, because it does seem to be hopefully a little bit more up and coming.
Last point on venue and jurisdiction, right? Again, depending on the contract, just make sure that it makes sense, right? If sometimes you may not have the choice. If you're going into business with a larger entity and you want their business or you want to work with them, then you may not have the bargaining power to change the venue or jurisdiction. But what this basically means is, if there is let's say you sign an agreement, and any dispute, either resolution or forum, so like the law that's applied or where you have to go to dispute it, is in New York, then you are going to be going to New York if you have a dispute on the contract.
Yeah, go ahead. Is it you? Question again. All right.
No, yeah. So entire agreement. So most agreements will and should include a provision that the contract represents the entire agreement of the parties. Indemnification. So indemnification is the requirement that one party of the contract, bears the cost of the other party. So some contracts might have hold harmless provisions or indemnification provisions. So if you agree in your contract to hold someone harmless, you're agreeing that person, you're agreeing not to hold that person liable for anything coming out of the contract. So if someone, does something wrong in the contract, if you have that, if you might not be able to sue them or get any, payment from them. If you indemnify someone, you're agreeing to protect them from liability or loss that may arise from the transaction. So if you sell like ingredients to a restaurant, and you have this in the contract, and someone gets sick at the restaurant, you might be liable for that. That's kind of what indemnification means. Confidentiality controls how a party must treat the other party's confidential information. So you need to think about if you have confidential information that you want the other party to keep secret, or even if you don't, you need to check the contracts to make sure if there are any obligations for you to protect someone else's confidential information. And sort of going off of that, you need to pay attention to how confidential information is defined. It could be defined in the contract. In one contract, it could be defined a different way than another contract. So you need to make sure you understand what is confidential information and what obligations you have.
The obligatory extra context here. For the confidentiality provisions, it's also smart to think about maybe some carve-outs you want, whether you want, your employees to be able to talk about the business, and so maybe only talk about information that's publicly available, or which is, you have consented to via written consent. But that way, then they can talk about their experience at your workplace or at the business, and give you, some positive reviews or whatnot. Also carving out from employment documents, you have to keep this confidential. That's somewhere you might really think about confidentiality, because, those people have your trade secret. We'll talk about trade secrets, but those people know your trade secrets. Those people are well informed about your business, and so having confidentiality provisions in employment documents is probably pretty crucial in some industries. One more point. Sorry, Jesse.
No worries.
The entire agreement provision that just brought to mind the fact that you may actually have multiple agreements interacting with each other. And what I mean by that specifically, and what's most pertinent probably for you, is there may be, a form agreement, a master agreement that you have all your provisions in, all this legalese that we're talking about, you have that in there. And then you're going to have an order form, a work order to the side that actually is going to list all the services you're actually providing, list the actual payment that you expect. And so you need those documents to interact with each other. So in the entire agreement provision, it might reference in any work order attached here too, attached to this master agreement. You don't need to legally words like here too. And the work order should probably address the master agreement. It should say all the relevant provisions are in the master agreement. If there are any conflicts between the two agreements, the master agreement will control, or the form, the work order will control. That's something you'll have to decide. But those two agreements should be interacting with each other and referencing each other and making sure nothing conflicts there. And if it does conflict, how to remedy that conflict. Which document will control.
So another key provision is the force majeure. So this provision is to address the situation where there's a major event outside of both of the parties' control that would prevent them from completing their obligations under the agreement. And an example would be a global pandemic. If something like that happens, you want to consider if the parties don't have to comply with their obligations under the agreement at all, or is it simply terminated or simply suspended for a certain amount of time? Do they have to at least try to fulfill their obligations? Do you want to list specific events that this provision will apply to? And also if there's any sort of notice that's required to be given to the other party.
Yeah, we've seen during COVID a lot of small businesses discussing their rent obligations, and it seemed like it's 50-50. Like they would ask if they have to pay rent. Well, we'd ask what the force majeure provisions are, or if it's a service related contract, and the services they're providing couldn't be provided because they couldn't go in to do their work, we'd ask like, well, what does your force majeure clause say? And because of the pandemic, we've really focused on this clause and the required notice or ways to give like a grace period to your contract in order to fulfill those obligations.
So intellectual property, or IP, provides for ownership and usage of intangible assets and creations. So contracts might include provisions about who owns the IP, how the different parties can use each other's IPs. So you need to consider whether you have IP that you want to protect, and what provisions you should put into a contract to protect that. And even if you don't have IP, you need to be aware of limitations that you're signing on to for other people's IP. So just paying attention to those clauses in the contracts and what limits and obligations are there.
Yeah. Go for it.
On this point, you want to note that if you're providing a service as a content creator or something like that, you definitely want to protect your IP. And if you are licensing or not licensing, but paying someone to provide you with IP, you want to make sure that you have certain ownership rights. So typically what we see here is if you, whatever IP is created is typically owned by whoever paid for it. But you want to also make sure that, if you're providing the service, that you are able to use the knowledge that you've gained to continue working in that field. So I guess the example we like to give, it's like every time you are contracted out to create something, you're building something new, but you're also developing skills on your back end that can help you in your next project. And so you just want to make sure that the provision allows you to use and to retain those skills. And one other thing to consider is whether or not you can like show the project that you created in like a lookbook. For example, wedding photographers typically no longer own the photos that they take for their clients, and the clients can do whatever they want with them except for selling them and using them in commercial settings. So basically, if I got married or after my wedding, I can just go ahead and start selling my photos online and just profit off of that. However, that makes sense too for the wedding photographer, because they don't want to just have that one-time sale. However, as a wedding photographer, my photographer was able to retain a few photos to include in their lookbook. So like as kind of their toolbox or their photo albums, like as a way to show potential future clients what kind of art or photos they can take.
So there's a lot on the screen right now. So this kind of goes through the different types of IP, how you get it, and examples. But we kind of wanted to just focus on trade secrets, which so it's a type of information. It's a formula, a way of doing things, a technique that is confidential and is essential to a business. And specifically, we want to make sure that there's situations where people gain trade secrets when they're working for certain companies or whatnot, and then leave and start their own companies and somehow trip up either a non-compete or violate trade secrets by starting their own companies. So just for you need to make sure that you're not violating anyone else's trade secrets, and if you at one point have employees or whatnot and have trade secrets, you need to protect your own trade secrets.
One thing to highlight on trade secrets and non-competes and whatnot is that California generally is a very competitive friendly state, but you just want to make sure that you're not running afoul to any of the laws. I know certain states do enforce non-competes. And so if you have any questions about what your employment agreement or your service agreement says, we highly recommend that you just talk to a lawyer and make sure that all makes sense. So steps typically when you want to look at IP is if you're choosing a business name, brand name, or trademark, we recommend that you first look at the U.S. Patent Trademark Office website to see if there's already something registered. You can always use Google first as a first instance as well. We also recommend after that looking at the California Secretary of State business search to see if a name has already been claimed. And with that, with trademark and names, if your name is too similar to someone else's, for example, like if a customer is going to likely be confused between like Al's Barbecue and Al's Best Barbecue, then your trademark application will probably be rejected. And if you're already doing business with a confusing name or a name that's very similar to another competitor within the same industry, the third party could take legal action against you for infringing on their rights. We also recommend that you check availability of the name via website domains, so Google again, or social media accounts to see if that name's already in business, local to you or otherwise. There's some tips to creating your own business name and brand name and trademarks. Consider registering your domain name, creating social media accounts early if you can, or if you want to, and to prevent. The other thing too is you want to do that to prevent others from taking them and to ensure that customers can find your business easily.
Also, just something to note with your business name is, what entity you choose will determine, at least the formal legal entity's business name, right? An LLC will have LLC in the name. A corporation will have either corporation or incorporated, or its abbreviations Corp or Inc. in the name. So that's something to keep in mind. The state of California will actually reject some names if they're too similar to others, just based on literally just they have the same name, not even if it's like a trademark that's too similar, that because it's in the same industry. So that's something to note, especially when you're looking on the Secretary of State's website in picking a name. And then also if you're doing business as a different name, so maybe your legal entity is named Jacob Gint LLC, but you're doing business as the Best Lawyer Ever LLC, or just Best Lawyer Ever business. You will have to file in your relevant county or city. It's pretty local, and indicate that you're doing business in that county as this other name, but you are registered with the state as your formal legal entity name.
Right. Another quick example is Google actually is Alphabet Inc. and they go by Google. So.
Some big points. I think we kind of went over these already, but avoiding oral on contracts, write it down. It's really maybe not easy to write down, but it will provide a lot of legal surety.
And if you wanted to, if you have a contract already there and you want to amend it, like don't just say, hey, let's just make an oral agreement. Just write it down and just say on this amendment, this amendment amends the original contract and both parties can sign it. Amendments can be as simple as just bullet points to add on to a task or just add more services, but we highly recommend that you avoid oral contracts. We ask that you remember to sign the documents in the name of the entity. Again, your entity signed by your name, comma, CEO or president of, rather than so that will create the distinction that you're signing on behalf of your entity rather than in your personal capacity.
Be aware of dangers of complexity, right? Even as lawyers, we try avoiding this, and you guys just aren't trained as lawyers, and so it would behoove you to keep it as simple as you can, right? The more complexity you provide, the more gaps that you create that you didn't realize, the more misunderstandings you might create, and so to the extent you can, keeping everything else we've said in mind, which is quite a bit. To the extent you can, keep it pretty simple.
That's right. And if you need to add a caveat or like a second condition, we typically say, hey, just another bullet point rather than trying to add it into a sentence with extra commas, because that just creates all sorts of issues. We recommend that you avoid agreements that limit future flexibility or could have unintended consequences. Again, if you don't understand the provisions, we highly recommend that you talk to an attorney or go to a legal services or a clinic to see if they can help you understand the provision, avoiding limits, avoiding agreements that limit future flexibility. We want to make sure that the confidential, for example, the confidential information session isn't so limiting that you are essentially barred from that industry. And if so, you may want to consider either negotiating the contract so that it removes those limits, or potentially, if the business decision is there, like to avoid that contract, or to seek a different business partner.
And then finally, form contracts from online. So we understand people don't just have their business contracts in their back pocket all ready to go. Almost surely you will look online for some examples of contracts that you may use in your business. They're not like handed down from generation to generation or anything. And so while we don't expect you to like read every single contract you ever interact with, I know I don't, and I'm a lawyer, it's good to really pay a lot of attention to your form business contract, right? If you have a service agreement you're going to use with all your customers, it's really good to, yes, you'll get one from online, but really read it, really understand what it says, be free to revise it for your business context, right? Because it's just some random agreement online, right? That's all it is. And it's helpful to first, make sure that it's governed by, your state's law. If possible, have an attorney, review it, or go to hopefully a pro bono clinic and have an attorney there review it. And finally, just read it very well for your own understanding. You should probably understand what every provision says. It's your contract. You may need to negotiate it with your customers. You may have work orders attached to it. And so just being really sure, if you have, a few specific form contracts you're going to use, to be sure of what they say. That might be the end. We only have a few minutes, unfortunately, but happy to take any questions anyone may have.
Hi, everyone. We've been compiling a list of questions. There have been a few in the chat, which I think reflects how important this information was. We have 5 questions, which I'll go over and ask them in the remaining few minutes. But one thing I also want to highlight, well, one, thank you so much, everyone, for presenting. And I know there were a few references along the way of you should really have, if you're able, an attorney review certain contracts, or maybe get advice specific to your entity, specific to your business on entity selection. These are 2 services that our small business legal clinic help a lot with. I think what happens a lot, sometimes a business will have a form contract or some points that they want to memorialize in an agreement with a customer or with maybe one of their employees. And we help them form these contracts. And if you're eligible, connect you with an attorney at one of our clinics to, approve upon what you already have and to confirm that what you have is valid under California law and in the industry that you're working in. So I do encourage everyone, and I put a link in the chat to apply to register for our clinics. There are eligibility requirements as I said earlier today. But let's get started on the Q&A. The first question that we have is from Hannah Braco, and the question is, what are the pros and cons of DBAs for an LLC? Is there a limit to how many DBAs an LLC can have? And this is actually a question that we get relatively often in our clinics. So I'll leave it to the panel here.
I don't think I've heard of the limitations on how many DBAs you can have per LLC or per entity. I would personally recommend that the entity or the business owner focus on creating one brand and just creating more presence around that. Of course, that's also a business decision.
Yeah, and as long as you're keeping to the formalities, right? You're applying for DBAs in the relevant counties. It sounds like you might have a breadth of business names, but making sure that those breadth of business names are filed in the applicable counties in every single county you're working in. That again is a very county specific requirement. Some are more annoying than others. Some require newspaper ads. Hopefully that doesn't apply to you, but
Right, right. In New York, I think it does require a newspaper ad in I think 30 days or something like that. Um, so it's county by county. I'm just thinking from like a practical perspective, right? If you have different names, then if you hope to be on, or if you plan on being on Yelp, then like your reviews will be spread out across X amount of names versus all concentrated on one. So
yeah, and Matt, if you have more experience, we don't have honestly that much experience doing DBAs. So if you have anything to add, feel free.
Yeah, I'll just add one thing that we've been advising businesses to, and this is another plug for the Small Business Clinic. A lot of it depends on the two types of businesses or DBAs you may want to run within the LLC. If they're very different types of businesses, it may not be best practice to do that, because if one business is not doing well or has liability, it could take both of them down together, right? They would be intertwined. So it might be best practice to have separate LLCs for the different, DBAs or types of businesses that you're doing. But it is something that, would be specific to your business. So if you, and then the types of businesses that you may be running. So if you are able, please, or interested, please fill out the application to meet with an attorney so they can analyze, the specific facts about what you're trying to do. I'll move on to the second question, and it's from Annalena Garcia, who is here. And her question is it common to combine contracts, different types of contracts, or is it kind of better practice to have singular contracts for, specific purposes?
I would say, it depends on the counterparties. Definitely if you're mixing counterparties, right? If you got different counterparties for one contract than another, obviously don't. And even when you do have the same counterparties, in our practice, we separate contracts a lot. It makes it very clear. It makes it clear what you're negotiating, and you can always reference the other contract in a contract. You can always make them interact with each other. But all it takes is an extra signature, and it's usually worth the clarity you're getting. Whether it's separate services you're providing, or just if you're going to negotiate one contract but not another, that makes it more simple too. So that would be my general recommendation. I don't know.
Yeah, I think I generally recommend that you keep them separate as well. When you start incorporating multiple parties and the conditions that every party has to perform in order for the contract to happen, it can get complicated very quickly. So at that point, if you had, like, let's say three parties that are all going to do business with each other for for a certain service to happen, I'd say, hey, like, reference them all in this master services agreement, but then have the different parties all sign their own contracts and that these are the services that they're going to provide, and reference that MSA. If you're speaking about whether or not you just want to have one big form agreement for the different types of services that you might provide, I think that would be ideal. What I would say is that create that form agreement, but leave the services and say, like, services provided, see Annex A of an agreement, and in that annex you can say, okay, these are the services for this company. In that case, you can just reuse that document, of course signing it with each party every time.
Yeah, and that's actually a good example. Work orders, we go through tons of companies' work orders. Work orders are incredibly, like, here's 20 different services we're providing. Here's the prices for each, the price schedule, and this is your whole entire invoice. Yeah. But if there's different conditions for being paid, or something where some conditions apply to some services and not others, it's really worth thinking about whether you want to break it out into different contracts.
Sorry, we're talking super broad and hypothetically because we don't know the specific facts or things that you're thinking about. So here's a plug for ICLS. Definitely apply if you can, and you can present your specific facts or what you're thinking about at the clinic in a couple of weeks.
You took my plug from me, but I think that it depends a lot on the types of agreements, and we talk about these issues a lot at our clinic, and it will depend on what you're trying to do. But in general, if there are conceptually different things that you're trying to accomplish with a contract, it's often better to have them separate. But again, that's just a generality. Sometimes it does make sense to combine things. But yeah, I agree completely with the guidance that you provided. Our next question is from Hannah Braco again. Should you have a contract with vendors that are buying products from, that you are buying products from if these products will be used as ingredients for your product?
I guess that would be an industry standard point. You know, I would think that if there is going to be a contract, it's almost usually the vendor's contract that you would be using. And to the extent they don't have one, you know, it generally might be a little impractical from a business standpoint to force one upon your vendor. Now creating an invoice or something might be appropriate, especially if they're pretty innocuous. You know, it sounds like ingredients. I don't know if you have other context you'd want to provide.
Yeah, without more context or like, you know, what you want to do from a business perspective, it's hard to provide general guidance on this. But, you know, if you're relying on a very specific type of ingredient or a specific type of fabric from one store, and this is like really crucial, then it might make sense to make, you know, form a contract. It depends also on your bargaining power. Like if you want to be the only, like if you find a very special ingredient or something that's very rare, you want to be the only person that has access to that. That could be a potential reason to create a contract, but it's very business and fact specific.
Thank you. And I agree with that. And I think that in general, it is good to get things in writing. And I like the suggestion about if you don't have a contract and maybe practically you aren't going to force the vendor to create one, like having a clear invoice with, you know, what you are receiving and for how much, and those details are really helpful to avoid if there's, you know, a dispute maybe later. The next question is, if your business is a sole proprietor, if you're operating as a sole proprietor, is the signature under the owner's name only and not the DBA, or is it under the owner's name or the DBA if they have one?
I think you could do either. I would probably recommend the DBA just because it's still your name. So I would recommend putting the DBA, you know, your company name, having a line, right, a blank line where you'll sign the name and underneath it say name and then print your name, right? So it's a printed name plus the company name, just so there's no confusion of this. I'm operating as a sole proprietor. This is my brand. I don't think there'd be any confusion, which would lead to like extra legal liability or something in that instance. Just understanding that DBA is not in any way necessarily protecting you from like a lawsuit.
Yeah, I think at that point it would just be a contract clarification point on the contract. So it'd be sole proprietor license name, DBA that name. Otherwise, I don't think there's any liability protection at that point.
Great. And I think our last question, and thank you for spending a few minutes over. Our last question is, if you're receiving reimbursement for mileage as a sole proprietor, where would you start that mileage from if you usually work remotely and travel a lot? I'll open it up to you, and I have some thoughts as this as well. But
you're welcome to say your thoughts. I don't think we're going to be very clear on this one.
This question is from Shannon Beasley, and I think it's actually a very popular or a pretty helpful question right now, especially now that we are gas prices and mileage or costs are a lot higher. And I think a lot of this will depend on your agreement, because if you are an independent, if you're an employee, that's very different than if you're operating a sole proprietorship and you're an independent contractor or contractor for other companies. And this might be something you want to lay out in the agreement. If not, I would usually say, and this is what we do in the employment context a lot, is if you would start your mileage for whatever amount that is off of your normal path. So if you're working remotely, that would be your home office. And if you normally go into an office sometimes, that would be kind of expected. But if you're doing trips or mileage for a company that takes you off of that path, you would do you'd start the mileage for that extra amount of time. So you would take away what is, normally you do, and then bill them for that. But I do think that this is a question, since you're a business and not an employee of this company, that you would want, to be laid out with the employer, and I'm sorry, with the business you're contracting with.
Agreed here. So
let's see. I think, unless someone please raise your hand if we missed one of your questions, but I think we got through the questions that were presented during the webinar. I am seeing, I'll just say, I'm seeing a lot of thank yous and to the questions, but generally throughout the webinar, I will echo that. This has been extremely informative for us here today, and also just super informative for us as an organization that is constantly trying to keep up to date on best practices in these, in all areas, but especially these two areas. So I really appreciate the information that was provided today.
No, absolutely. Thanks for having us, and good luck forming your businesses / drafting your contracts. Yeah. All right, thanks.
Thanks,
All right.
everybody.
Thank you all so much.